appeal in the matter of King on the application of British Medical Association and the King on the application of Fire Brigades Union and Nugee and HM Treasury and another.
Good morning, Mr. Short. Thank you to everybody for your very helpful skeletons. Thank you for the reading list and the timetable. And you can assume that we have done our very best to read very widely.
I'm grateful. May it please your ladyships, your lordship, I appear, as you're aware, for the Fire Brigade Union, and two of its members, Joshua Dunn and Chloe Reid, I appear with Martina Murphy, who's behind me. To my left is Fenella Morris, King's Counsel, with her Jennifer Phelan, and to my right, appearing for the respondents in both appeals, is Mr. Nigel Giffin, King's Counsel, together with Richard O'Brien, soon to be, I understand, King's Counsel.
Congratulations.
So,
and Mr. Short, you've handed up copies of the additional authorities.
We have, yes.
That's lovely, thank you.
I think they were e-filed yesterday.
Yes,
but,
yes they were.
There as well. Just to touch on the organisational matters, particularly after the confusion caused last week by my failure to rename our...
I'm sorry, that was just me.
Well, I don't disagree with your ladyship so early. I think it was just me, and I'm very grateful to Mr. Giffin.
I just wanted to be certain I was reading the right thing before I began.
I'm grateful. In that case, I won't deal any further with the various bundles, other than to comment that authorities there are three bundles of authorities: a core bundle, a separate legislative bundle, because we thought that would be easier than turning between different bundles to deal with legislation, and something which on reflection is rather counterintuitively called the main bundle, because we hope to spend more time on the core bundles. The court has the draft timetable, subject of course to your views, but I think the idea is that I'm going to start until about 2:45 this afternoon. Then you'll hear from my good friend Ms. Morris until tomorrow morning, and then Mr. Giffin will take over with short replies on Thursday morning. Now,
and Mr. Short, are we right to think that there is no transcript?
That's right. Which does remind me, ordinarily I'd expect to pause halfway through each session for the transcribers, but possibly for everyone else as well. I'm not sure if the court would want me to pause halfway through.
I think we should plough on.
I'm grateful. And in that case, I will do that. There are 4 grounds in the FBU's appeal. One is based on construction, or the Padfield argument depends upon the purpose of the legislation, and grounds 2, 3 and 4 deal with discrimination. I'll deal with those later and together. The judgment, which is at tab 13, page 161 of the core appeal bundle, sets out the background in great detail. Paragraph 7 to 67, and gives an outline of the legislative scheme. So what I propose to do is simply go to the legislation and the legislation bundle in order to set out my case. I understand there are some people outside. Now, tab 3 of the legislation bundle, we have extracts from the Public Service Pensions Act 2013 Act. And page 13 is section 1, and it provides for regulations to establish schemes for the payment of pensions and other benefits in relation to certain description of persons. These include at E&F health service workers, fire and rescue workers, and these are the what I'll call new schemes. These were provided for regulations to be made to set up new public sector schemes after the part of the public sector pension reforms.
Mr. Shaw, I'm reminded by this that one of the new schemes is that for the judiciary.
Yes.
I think we've all proceeded on the assumption that they're not conflicted. Is that right?
Certainly, I don't think anyone's going to take a point. That would rather shortcut matters in an unhelpful way. It is that any judge, save for one who is already paid up in every pension scheme, could be involved in certain things. But I don't think anyone suggests there's any.
You don't have any objection? Thank you.
We had considered this in advance. So. No, my lord, there's no objection. Section 11 of the Act deals with valuations, and the valuations are required for two purposes. One is a typical purpose of working out what the total liabilities are and how much needs to be paid to meet them. And that valuation has to work out the actual cost of both the scheme and the connected schemes, or the legacy schemes, as I'll call them, which are the older pre-2015 schemes. And one sees that in subsection 1, which provides that the scheme regulations for the new schemes, which is a defined benefit scheme, must provide for actuarial valuations to be made of the scheme and any statutory pension scheme that is connected with it. Now that is defined, connected schemes are defined in section 4, subsection 6. That's in the additional bundle of authorities handed up today, but I don't think one needs to turn to it. The definition is that a scheme's connected if it provides benefits for the same persons or the same descriptions of persons. Subsection 2 says that the valuation is to be carried out in accordance with Treasury directions, and then 3 provides for those directions to specify in particular certain matters. And these deal with how and when it's to be carried out. At C, importantly I say, the data, methodology and assumptions to be used in evaluation. D, the matters to be covered. E, where a scheme under section 1 and another statutory pension scheme are connected, whether they're to be valued separately or together. And then at F, the period within which any changes to the employer contribution rate under a scheme must take effect following valuation. Now, all of those will be material to the ordinary valuation purposes, finding out how much is owed in terms of benefits, how much needs to be paid in order to meet those benefits. Some of them, though, also deal with the second type of valuation, second purpose for the valuation, which is the cost control mechanism that is at the heart of these appeals. And although the section does not expressly distinguish between the two purposes, some of these provisions are only relevant to the overall valuation. So that, for example, 3F and employer contributions, that depends on the what I call the main valuation, because the cost control mechanism doesn't affect the level of employer contributions. Now, 4 and 5 make more detailed provisions, but what I say is noteworthy here is that where there are references to the legacy scheme, they tend to be expressly stated. We see it, for example, at subsection 1 and 3e. And this is something that I submit is seen throughout the legislative scheme. And secondly, as I've said, much of this will apply to both types of valuation. Some applies only to the valuation that's not concerned with the cost control mechanism. And in his judgment, Mr. Justice Choudhury said it was striking that there's no limit to the purposes for which the matters in subsection 3 can be used. I accept that's true, but that's, in my submission, entirely to be expected, as valuations are inevitably going to be required for both purposes. The core provision dealing with the cost control mechanism, employer cost cap, is section 12, which is over the page 17. Subsection 1 provides for the scheme regulations for a scheme under section 1. That's a new scheme. Defined benefit scheme must set a rate expressed as a percentage of pensionable earnings of the scheme to be used for the purpose of measuring changes in the cost of the scheme. And there, in my submission, I say that the purpose of measuring changes in the cost of the scheme is the new scheme. And at subsection 2, that's called the employer cost cap. It's to be set pursuant to subsection 3 in accordance with Treasury directions. But in my submission, it is difficult to think of a much clearer way of expressing the purpose than subsection 1, because the purpose is to measure changes in the cost of the new schemes. Subsection 4 provides that Treasury directions may in particular specify certain things. At A, how the first valuation under section 11 of a scheme under section 1, so the first valuation of a new scheme, is to be taken into account in setting the cap. Now, pausing there, that is in practical terms the 2012 valuation. One awkward wrinkle in the legislative scheme is that this uses the expression first valuation, but the directions call it a preliminary valuation and call the 2016 valuation the first valuation. But it's the 2012, it's the original valuation that sets the cost cap, dealt with at A. B provides for the costs or changes in costs that are to be taken into account on subsequent valuations. Of course, in there, that includes the 2016 valuations of a scheme under section 1, new scheme, for the purposes of measuring changes in the cost of the scheme against the cap. And again, plainly they're the words I rely upon to indicate the purpose of this regime. C refers to connected schemes. So C says the extent to which costs or changes in the costs of any statutory pension scheme which is connected with a scheme under subsection 1 are to be taken into account for the purposes of this section. Now, those purposes, I say, are the purposes identified in subsection 1 and subsection 4b, i.e. identifying changes in the cost of the new scheme. Now, there is a slight difference in the wording at the end of B, purposes of measuring cost of the changes in the new scheme, and C, purposes of this section. But in my submission, that seems likely to be because the costs of the legacy schemes are certainly important in identifying the original cost cap. So one had to use the legacy schemes in order to calculate the employer cost cap. And in itself, once that was done, that wouldn't in itself identify changes in the cost of the new scheme, because there wasn't a new scheme at that time. It is simply how the starting point is identified. But that subsection does not, in my submission, broaden the purpose of section 12 and the cost cap mechanism to measuring the costs of the legacies, or changes in the costs of the legacy schemes. Subsection 5 deals with Treasury regulations, and it's the regulations must make provision requiring the cost of a scheme and any connected scheme to remain with specified margins either side of the employer cost cap, and for cases where the cost of the scheme would otherwise go beyond either of those margins, provisions specifying a target cost within the margins. So 5B, is dealing expressly and only with the new schemes, because it is only the new schemes that are governed by the cost cap mechanism. It's only the new schemes where the accrual rate or contributions are adjusted. 5A does make express reference to the connected schemes. Again, that, in my submission, is another example of an express reference to a connected scheme where that is to be taken into account. But it doesn't, that reference doesn't change the overall purpose of the section and the cost cap mechanism. What it does is that it recognises that there are members who will remain in the legacy schemes and who would otherwise be entirely ignored. And that's not the intention of this regime. But it does and did allow them to be taken into account, albeit on the basis of the notional costs of their ongoing service had they been in the new schemes.
I haven't understood that point. I think you might need to explain that in a bit more detail.
Yes. There were members on any basis who were going to remain in the legacy schemes. Their costs, or the cost of providing benefits for those members, would have been entirely ignored unless there was some provision to take into account the fact that there are, say, 10,000 people still in the legacy scheme.
When you say still in, do you mean have past service benefits in the old scheme, or are still accruing benefits in the old scheme?
I mean the latter. I should have said were still accruing benefits in the legacy schemes. On any basis, there were going to be active members of the old scheme.
So there are active members who are still employees, who are still accruing benefits in the legacy scheme?
In the legacy schemes, yes. These were the people who had transitional protection from the outset.
Was it always a design feature of the Act, because we're only looking at the Act at this stage, that certain people would not be required to move to the new schemes?
My Lord, yes. I think there's provision within it that allows transitional protection to be made, in particular where they are within 10 years of normal retirement date. I don't think that's sections in the authorities bundle, but it's referred to in the McCloud decision, and maybe I'll be able to dig that out over lunchtime. So there were always those people. There were also people with accrued benefits in the old scheme, so effectively deferred members of the legacy schemes. But their benefits retained the benefit of a final salary link whilst they remained members of the new scheme.
So if you're an employee in the service and you are moved into a new scheme,
yes,
retain your benefits for your service up to whatever the date is
Yes.
in the old scheme, and you retain salary linkage because the old schemes are final salary schemes.
No, you retain salary linkage whilst you remain a member of the new scheme.
Yes.
So if you leave the new scheme, even if you stay in service, so if you opt out, you lose the final salary link.
Most people don't opt out.
No,
No.
they don't. Although, in fairness, some people do. Some of the contribution rates were quite high, and during a time when pay rises were very low, the cost of living was going up. I think an atypical number of people may well have opted out, but most people don't. But in any event, you only kept your final salary linked whilst you remained a member of the new scheme. And so it was certainly a consequence of your membership of the new scheme that there would be final salary costs flowing through from legacy scheme accrued rights.
There will be other members of the legacy schemes, pensioners and deferred members who are no longer in service or no longer in the new scheme, who will have rights in the old scheme. Are they relevant to any valuation?
No, yes, they're relevant to the overall cost valuation. They are not relevant to the cost control part of the valuation. That was based on active members at the date of implementation on 1st of August 2015. And in fact, that fact that pensioners and deferreds as at the 1st of April 2015 were excluded from the cost control mechanism is something I'll come back to later on. But what I say the regulations allow to happen is that a notional cost of benefits in the new scheme was attributed to active members of the legacy schemes after 2015, because otherwise they would have been ignored. And also the final salary link for those who were members of the new scheme would also have been ignored. And the regulations allowed costs flowing from those things to be taken into account. And in fact, that is exactly what was done before 2001. So in my submission, the reference to connected schemes in subsection 5A doesn't broaden the purpose, certainly doesn't necessarily broaden the purpose, because it allows for a perfectly coherent regime such as the one that was in operation before 2021. That's not to say the purpose of the section was narrowed by what was done afterwards. It's simply to say that the purpose identified in subsection 1 can be furthered in a perfectly coherent matter, or a perfectly coherent way, by reference to those limited costs from the legacy scheme, because they reflect on cost changes in the new scheme, or arising from the new scheme.
I'm sorry, I'm being very slow. I haven't quite understood that submission. What we're looking at here is a statutory provision which is an enabling provision, enabling regulations to be made. So we're not looking at the regulations that are in the event made. We're looking at the scope of the section.
Yes.
Now, I understand the point you make that if you just read subsection 1, it tells you the purpose of setting the employer cost cap is to be used for the purpose of measuring changes in the cost of a scheme. If you just stop there, you you might think, and indeed you told us, that it was for measuring changes in the cost of a new scheme. But there is no doubt that 5A and 4C enable certain legacy costs to be included.
Yes.
Now, those costs are not, in the real sense, changes to the cost of a new scheme. They're changes to the cost of the old scheme. So this is an extension of what you would get from subsection 1 to allow you, for this purpose, to take into account costs of legacy schemes. Your submission is that's to be given quite a narrow meaning, if I've got it right, limited to the impact on the costs of the old scheme of active members, I think both active members who remained in the old scheme and active members who transitioned to the new scheme. But it doesn't say that here. I can't see the language here which limits it to that. On its face, it allows any costs of the old scheme to be included by Treasury direction. Is that not right?
My Lord, no.
Why not?
I say that's not right because initially taking 4.3, which is the first reference to the legacy schemes, that is expressly said to be for the purposes of the section. And one has to look elsewhere. So they're limited. They can't be taken into account for any purposes. And the purposes of the section, I say, are set out in 12.1 and 4b. And that is, they are clear statements of the purposes of the section.
Yeah,
so see...
I'm sorry to interrupt you. The difficulty with that is that the purpose, you want us to read for the purposes of this section, as if it read, for the purposes of setting the first cost cap and thereafter for measuring changes in the cost of the scheme.
Yes.
And you want cost of the scheme to mean the new scheme.
Well, my Lord, when it says the cost of the scheme, it does mean the new scheme.
Yes, the problem with that is, if all you're interested in is changes in the cost of a new scheme, then you wouldn't take into account any legacy costs, because legacy costs, by definition, don't change the cost of a new scheme. They change the cost of the legacy scheme. And what this clearly does envisage is that when you're setting the employer cost cap, you can take account of certain legacy costs. That's what it says.
Yes.
Now, that can't be for the purpose of measuring changes in the new scheme, because changes in legacy costs don't change the cost of the new scheme. They change the cost to employers and government and taxpayers of employing people, but it doesn't change the cost of a new scheme.
Well, my Lord, they do change costs which are treated as being costs of the new scheme.
Well, yes, I understand that. But then how do you identify which legacy costs can or cannot be treated? This is the critical question.
Yes.
Can or cannot be treated as costs of a new scheme?
And
I don't see in this section anything which tells you that.
Well, I was stepping back a moment. In my submission, the choice is between construing 4C and 5A in a way that is consistent with the purpose identified in subsection 1, or construing it so as to extend the meaning of subsection 1. And in my submission, they can be construed consistently where the legacy scheme costs or show or can be used to measure changes in the cost of the new scheme. So, for example, with the active members, the fact that there are 1,000 members in a legacy scheme is taken into account, and we know this is what was done, but we're taken into account for the purpose of the cost cap mechanism by assuming they were accruing benefits in the new scheme. So they have a notional cost. So the new package of benefits had a notional cost in relation to those members. And it's that cost that was included in the cost cap mechanism for the first 6 years. Now that's what was done, and no one has suggested it wasn't permissible to do that. And that is a way of identifying costs of the new scheme in a way that reflects on or that takes into account information drawn from the legacy schemes. And similarly, final salary cap, the final salary link is a cost, although it's not necessarily valued or wouldn't ordinarily be valued within the confines of the new scheme, but it is a cost that flows directly from membership of the new scheme. So they're both costs that flowed from the introduction of the new regime from 2015, and that is what is identified as the cost to be measured in subsection 1. That's what was done. Again, I make clear I'm not relying on that as showing it was the only thing that could be done, but it is something that could be done.
Mr. Short, I'm going to show a lack of understanding here. I fully understand that the final salary link may be a cost in the new scheme, flowing from membership of the new scheme. But I find the first example more difficult, that you've got actives accruing in the old scheme, and yet they're taken into account under this formula in the new scheme.
Yes. For
the CCM. Why?
Because the cost control mechanism was intended to identify the costs, say, of the new scheme, which would be the costs of the new benefit package that was being provided. Now, the costs of the actual benefits being earned by people with transitional protection were different, but they didn't result from the new package of benefits. They resulted from transitional protection. But they were still to be taken into account in valuing what's due, what's being built up because of the new package, because they were treated as having notional benefits in the new scheme.
Thank you.
And they may in fact have been earning more than that, but that's not because of the new scheme, that's because they had transitional protection.
Thank you.
Now that's they're my submissions on subsection 5 and regulations. 6 and 7, subsection 6, subsection 7 deal with what happens when the scheme goes beyond the margin. And again, it must be the new scheme because it's only the new scheme that's affected in this way. And in essence, either benefits can be increased, accrual rates increased, or contributions are increased or decreased depending on whether the breach is of the ceiling or the floor. But again, only in the new scheme. So in my submission, it makes perfect sense to focus on the costs of the new scheme because it's only the new scheme that can be affected by the cost control mechanism. The next provision I want to refer to is on the next page, section 22, and that is the provisions relating to protected elements. The public sector pension reforms were intended to provide a long-term settlement. Section 22 reflects that, and in essence, it meant that that during the protected period, and that's defined in subsection 5 as prior to the 31st of March 2040, so a 25-year protected period. The protected elements, the main structure of the scheme, which is the fact that it's career average, members' contribution rates and benefit accrual rates, could only be altered following a particular procedure involving consultation with a view to reaching agreement, and also laying a report before the appropriate legislature. And so those basic structure of the scheme was intended to be protected, and the government couldn't change it at will. There's an exception there, subsection 6, so that references to changes to the protected elements do not include a change appearing to the responsible authority to be required by or consequential upon section 12 and the employer cost cap. What that means is cost cap could produce changes in the accrual rate or contributions. But outside of that, those elements were protected. It's a procedural protection, but there is important protection there. And it would undermine, sidestep that protection if the government was able to change the or activate the employer cost mechanism by using its powers under section 12 and section 11 and 12 to change the way in which valuations were taken into account. So, for example, if it changed the assumptions by which valuations were carried out, if it included new costs.
Well, what's wrong with changing assumptions? I mean, you have to change assumptions at each phase. You know, assumptions as to longevity, assumptions as to discount rate,
yes,
and so on. Well, are you saying you can't change assumptions?
No, my lord, no. Although only some assumptions are changed in the cost cap mechanism. So
that's because the government made a decision to divide the costs of the scheme into what are called member costs and what are called employer costs, yes, and put certain demographic assumptions in one bucket and certain financial assumptions in another bucket. But that was a choice made when making the yes, regulations. It's not in the Act, is it?
No, my lord, no. But it would not be possible for, in my submission, consistently with the regime of the Act, to change assumptions with a view to changing the accrual rate by triggering either a breach of the ceiling or a breach of the floor. It would not be permissible to change what is valued by, for example, including new costs that had existed but weren't being taken into account at the earlier valuation. And in particular, for example, the pensioners and deferred members, as at the 1st of April 2015, who are excluded from the cost cap mechanism.
So once you've made your initial decision, you're stuck with it until 2040?
Once you have made your initial decision, you need to continue to measure changes in costs of the new scheme, and you cannot simply bring new costs in that aren't changes in costs, because they always existed, but they're simply altering the comparison. So you're no longer comparing apples to apples, but you're comparing apples to an apple and an orange, or to something different. So there must, in my submission, be some limit to the costs that can be added in on a subsequent valuation. Otherwise, the protection in section 22 is entirely illusory.
But there is a relationship between the protection in section 22 and a change appearing to the responsible authority to be required by or consequential on section 12 for a cost cap.
Yes.
Section 6. So how does that relationship work?
Because section 12 is there to measure changes in the cost of the new scheme. And if there is a change in the cost of the new scheme that requires an adjustment to accrual rates or contribution rates, then that can be done. But if it's not limited to changes in the cost of the new scheme, then there isn't really a relationship between Section 12 and Section 22 anymore, because it's possible to use Section 12 in order to achieve the very things that Section 22 says the government can't achieve without going through a particular procedure.
So it drives some coach and horses through 22 protection, you say?
Yes.
Because the Section 12 benchmark is not a benchmark, you can just move it about.
Yes. I know, exactly. That's the point. That's why I say that there must be some fetter on the costs that can be included, and the easiest fetter to identify from the language of the Act is costs resulting in changes in the cost of the new scheme, even if that is given quite a broad definition. And so the difficulty, and I accept it's a difficulty, but the difficulty of deciding exactly what costs can and can't be included is a difficulty for my learned friend as well, unless he takes a purist position, says the government can include absolutely what they want without any fetters whatsoever. And in my submission, that's unlikely to be the case and would certainly make Section 22 entirely illusory. I've mentioned the final salary link, and that's dealt with in Schedule 7, which is at page 31 of the Bundle of Authorities. And I'm not going to go through all of it, but the gist of it is in subparagraph 1, which is where someone's a member of a legacy scheme plus a member of a new scheme under subsection 1, and in those circumstances, effectively, paragraph 3, earnings that are to be regarded as derived from the old scheme service mustn't be materially less than the earnings would have been from the person's pensionable earnings derived from that service had the new scheme been old scheme service. But quite complicated, I won't go through all of it, but the gist is you kept your final salary link whilst you were in the new scheme. Now, that's the Act. The scheme regulations are behind tab 7, that's page 81 of the legislation bundle. In the firefighter scheme, it's sections 150 and 150A. 150 deals with the appointment of an actuary and actuarial valuations. Valuations are 5, evaluation of the scheme and any connected scheme. And then over the page at 150A, the employer cost cap, you see the figure is 16.8, and at subparagraph 4 makes clear that if agreement isn't reached after 3 months, then the Secretary of State must adjust the rate of accrual either up or down so that the target cost is achieved. The equivalent provisions for the NHS schemes are at tab 9, page 90. Their figure is 11.6%, and it demonstrates that what's being measured is changes in costs. So that if the 2016 valuation for both schemes had identified a rate of 14%, that would have been a floor breach for the firefighter scheme, a ceiling breach from the health schemes.
Sorry, where is the NHS regulation?
It's page 90 onwards. It's set out over a few different paragraphs,
Thank you.
but it's to the same effect. The cost cap regulations, these are the ones made under Regulation 5, I'm sorry, under subsection 12.5, are at page 83. One can see made under section 12.5, page 83. At page 85, Regulation 2 says the relevant scheme is a defined benefit scheme and any connected scheme. And then the margin is in Regulation 3. In fact, this shows the rate being 3 percentage points, but that's a 2022 amendment. At the material time, the margin was 2% above or below. The directions begin at page 93.
Sorry, just pausing on Regulation 2, the cost cap regulation from paragraph 5, which defines relevant scheme. Is the passage in brackets, which is any connected scheme, ultra vires on your argument? Or have I just misunderstood your argument?
I haven't explained my argument properly. I don't suggest that's ultra vires. No, that's
Oh, well, it's probably my fault not following it.
within that's inevitably my fault if that's the case. But that was permitted, I say, because it permitted the costs which were being measured till 2021 to include the notional costs of service had members been in a new scheme. The directions, so say, begin at page 93. I think it's fair to say that even given the context, they're quite complicated, but they don't, it doesn't, it may, however, be helpful to have an overview of how they work, and I'm going to endeavour to assist with that. One sees at page 93 that these were made under sections 11 and 12 of the Act. The material parts begin in part 2, valuations, regulation 3 onwards, or sorry, direction 3 onwards. Scheme identified. Reference to a scheme means a scheme made under section 1 and any connected scheme. Again, as I say, whenever both schemes have to be taken into account, both schemes are referred to. At 6, it refers to the effective date, and this is where it says the first valuation must have an effective date, which is 31st of March 2016. That's not the way first is used in the Act. The implementation date has to be specified no more than 3 years and 1 day after the effective date. For our purposes, 1st of April 2019, and the implementation period is 4 years from that date. So the actuarial valuation is carried out as at 31st of March 2016. That is implemented during the implementation period, which is 1st of April 2019 until 31st of March 2023. Paragraph 9 onwards deals with various matters to be taken into account, membership data, and at 10 onwards there are provisions as to the methodology and assumptions that are to be used. It includes various things such as assumes the rates of increases to pensions, something called the scape discount rate. Well, these are unfunded schemes, but SCAPE is used to create a notional balance of past contributions and benefits, assuming a discount rate that's identified. But there's no fund here. These are unfunded schemes. But it allows one to calculate what the fund would be if there had been a fund. So schemes are treated as having notional surpluses or notional deficits, even though the money is actually spent as it comes in.
If it's important, I'm not sure it is, but if it's important to understand that, I haven't understood it. I mean, I understand entirely these are unfunded schemes.
Yes.
I understand how you value a funded scheme. You look at the assets you've got in the fund and you compare them with the past service liabilities on the basis of assumptions. That's a very familiar process to anybody who's had to look at the funding of funded schemes.
Yes.
I have not understood how you value the past service liabilities of an unfunded scheme in order to determine whether there's a surplus or a deficit, because you don't have a fund to measure against.
No. What you have is the...
So my first question is, do we need to understand this?
It is taken into account in the system. So in the cost control mechanism. So in my submission, yes.
Right.
It would be helpful.
In that case, I will listen.
But I'll try and explain. What happens is they do know what contributions have been received from members, and they do know what contributions have been paid by employers. The SCAPE figure allows those contributions, or the figure produced by those contributions, to be calculated or put through a system so that you can calculate what the fund would be if those payments had been placed into a fund and kept with allowance for inflation and notional investment returns.
What, from the beginning of the scheme, or from when?
Probably from the last valuation, which is all that's necessary. So this is done all the way through, and it allows the government to know this is how much has been provided in the past. And in fact, those sums have been spent. But you know how much has come in, you know how much has gone out. If it had been put into a fund and experience had reflected the assumptions made in the SCAPE figure, you know you would have X billion pounds in that fund. And so in fact all of the schemes were treated for the cost control mechanism as having a zero balance when they started, but actually every scheme was treated as having a fund of it's page 120, schedule 2 of the directions. All of the funds were treated as having a notional asset value of this much money at the time of the first valuation. And then,
so I've understood there's a notional pot of money at a particular date, which seems to be quite a long time in the past. I mean, some of them date back to 2004.
No.
And then you apply notional returns.
yes.
Are those notional funds to cover the entire cost of the legacy schemes, including deferreds and pensioners
Yes.
who never come into the new scheme?
Yes, that's right. But that is taken into account for the overall valuation that values what the entire liabilities are, not for the purposes of Section 12 and the cost cap mechanism, but for the more generic valuations that work out how much money there is notionally how much money the employers need to contribute to the schemes to keep them funded, even though there isn't a fund.
So
It's all these are all notional.
they're all notional. I understand that there isn't a real fund.
Yeah.
But you take the liabilities of a legacy scheme. Let's take the first one, civil servants, PSPS. As at 2007, it had a notional asset value of 97.7 billion. I suppose its then liabilities were 100 billion. There would have been a shortfall, deficit. Does the civil service then have to pay deficit repair payments in the new civil service scheme to cover that shortfall, notional shortfall in the old scheme?
No, the employees, the active members won't, and the cost control mechanism doesn't take account of any of the people who were pensioners or deferred on the 1st of April.
What about for the employer contribution rate in the new scheme?
There are two, if you like, employer contribution rates. One is the notional rate captured by the cost control mechanism. That won't be affected by those things. The actual sums paid by the employers, yes, that has to cover everything.
So that covers shortfalls in the legacy schemes.
That covers all of the shortfalls in the legacy schemes. It includes the actual accrual, future accrual in the legacy schemes, if that's the main overall valuation that's used to identify the employer contributions. And that, I hope, will be clarified once I've finished the directions.
Sorry.
But it's not entirely straightforward. I don't think it's just because of how I'm explaining it. I think it is quite complicated and very, very notional all the way through. But my lord, if I can get through the rest of the directions, I hope it will be clearer how it works.
Okay. I can't say I'm 100% confident. It's not your fault.
I'm hoping there was a comma between those. But maybe I'm not going to press for an answer on that. I'm just going to move.
You could assume a notional comment.
I'm very grateful. Paragraph 20. There are the more typical things, or paragraphs 19 and 20, the absolutely typical things you expect an actuary to do about lived experience with the scheme, mortality rates, entrance rates, ill health retirement, and the like analysis of demographic experience. Then at paragraph 21, it said the directions deal with the contents of the valuation report, what it must include. Paragraph 21 is one thing. 22 deals with one of the two main bits. Paragraph 22 is the employer contribution rates. And this includes a statement of the liabilities of the scheme at the effective date, the notional assets of the scheme, and information about those assets, the contribution rates, contribution yields, and the employer contribution rates. So that's going to look at what the scheme has to pay out and what's either come in or is treated as having come in and been accumulated in the past. But that works out how much the employer needs to pay to keep the schemes notionally solvent. 23 deals with the cost cap, and that's a separate thing, and it deals with various complex elements, but I'm going to come on to those in due course. But it values something very different to the overall costs of the scheme. Now, so I'll call first the employer contribution part of the report and the cost cap and they're dealt with in more detail at 24, 25 onwards. But before I do that, I'm going to jump to the end and part 3, which is at page 114, because actually what happens first is the employer cost cap is identified. That's 16.8% figure in the cost of firefighter scheme. That was done by reference or in the way set out in part 3. So chronologically this happens first, and this where it includes the rate at 48, the rate of the employer cost cap set in scheme regulations under section 1 must be equal to the proposed employer cost cap calculated in preliminary valuation of the relevant old scheme carried out in accordance with directions 50 to 53. So this is the section 12.1 figure, and it has to be carried out by reference to the legacy scheme, because in 2012 there were no new schemes. It also uses the description preliminary valuation rather than first valuation, possibly for that reason, I don't know. Contents of the preliminary valuation are identified under paragraph 50, and as is made clear at 50b, this is a valuation of the old scheme, but it sets out the effective dates and so on. But what's the substance of it really appears at paragraph 53, and it identifies the employer cost cap as being contribution rate required to cover the expected cost of benefits accrued by members of the old scheme during the implementation period. And remember, that's 2016 to
16 to 19? No,
in fact, I think this is yes, 16 to 19, and
is that right?
It might be 15.
The implementation date is given at the bottom of page 114. I think 1st of April 2015.
Yes, it's 15 to 19 because the second it's 4 years, not 3 years.
4 years from the implementation date.
Yes, and then the next implementation period is April 19 to
23.
March 23. But so it's notional service or expected cost of benefits accrued during that period, less member contributions expected during that period. That's B. But and importantly, and maybe this all I've really been leading up to, importantly at subparagraph 6, for the purposes of calculating A in paragraph 1, expected cost of benefits accrued by members of the relevant old scheme should be determined as if no members of the relevant old scheme have any entitlement to exceptions made under sections 18.5 to 7 of the 2013 Act. They are the transitional provisions in the 2013 Act. So what that means is the original figure, employer cost cap, calculated under the directions for the purposes of section 12.1, was the figure of benefits to be accrued under the new scheme structure, even if someone was, as it happens, accruing benefits in the old scheme because they had transitional protection. So that's the starting point, is the cost of future benefits under the new scheme structure. And with that in mind, if I can ask you to go back to paragraph 24.
Before you do that, I've understood that if you look at Regulation 53, what you're comparing is two things. The expected cost of benefits in a period from 2015 to 2019 and how much the members are contributing.
Yes.
I've not understood in what sense this is a valuation of the old scheme as a 2012. It looks as if it's just valuing what's going to be contributed and accrued from 2015, which will be in the new scheme. I haven't understood how it works.
Well, a starting point is that the directions say it's a valuation of the old scheme, but the new scheme doesn't have any members.
Well, in 2012 it doesn't. In 2012 it doesn't.
In 2012 it doesn't.
Yes, but the implementation period is 2015 to 2019, yes. By which time everybody except those with transitional protection will be in the new scheme.
Yes. And
you have shown us, I think, that you assume that nobody has transitional protection. So everybody's in the new scheme. So in what sense is it a valuation of the old scheme?
Well, because the data it's using is based on the old scheme, because the members it's identifying, some of them are still going to be in the new, still going to be in the old scheme. So it is, as with all of these things, it is a notional calculation. It doesn't even include all of the actual costs. It includes some of the costs, because only some of the costs are being treated as member costs, and it's only certain changes that are being identified. So the employers are always paying much more than 16.8%, but that is the notional cost that's been fixed to measure relevant changes in the cost of the new scheme, the new benefit package.
I'm still very confused about paragraph 53(6). I understand what one leaves out, the transition, but it is still talking about the expected cost of benefits accrued by members of the relevant old schemes during the implementation period. And if we put that together, I think this is also what my Lord Justice Nugee is saying. We put that together with what the calculation in 53(1), it is that therefore accrual in the old scheme or accrual in the new scheme?
It is accrual in the old scheme on the assumption that the benefits of the new scheme are what's being accrued. So what it does is measure the cost of providing new scheme benefits. It does that whether sensibly or otherwise by reference to members of the legacy schemes, because they're the only ones who existed in 2012. But it said it identified what the figure would be to pay for new scheme benefits. And that's why I say the references to the connected schemes are to allow that to happen. Sure, there would have been other ways to do it, but what was intended was to work out what the new scheme benefits were going to cost. And that is demonstrated by the directions. It's not limited, except it's not limited by the directions, demonstrated by the directions. And the subsequent valuations do much the same thing, although now there are actual members of the new scheme, so they're taken into account. Members of the legacy scheme are taken into account on the assumption they're accruing the new package of benefits, so that the cost of the new package of benefits can be valued, plus the final salary link, which I've mentioned. And that can perhaps go back to show how the subsequent reports work. It will be I've done what I can, but the issue is these are all notional calculations, and in essence I really say that you should compare like with like from the preliminary to the future, or to the subsequent valuations, and work out what the new package of benefits is going to cost. So going back to the employer contribution rate, the actual employer contribution rate part of the directions, page 104, paragraph 24, 25 onwards, there's quite a lot of detail, but the employer contribution rate is calculated as set out at paragraph 29. And this, in essence, identifies what is going to be needed to fund the schemes as a whole, the entire pension provision, and it deals really with three things: future service cost in the next implementation period, that's the actual cost including any transitional protection; past service costs, where the liabilities exceed their notional assets, which is only going to be a cost if previous assumptions are disappointed, and might be a surplus if previous assumptions are beaten. So, as it happens, what happened? Longevity didn't improve as had been expected. There was wage restraint. All these things had an impact. And those costs less the member yield, the expected yield from member contributions, gives you the actual employer contribution rate. It is complicated because none of the dates match up, and there are various catch-up and adjustments made for that reason. But that's the actual cost, future service costs, actual past service costs, using these notional calculations, less member contributions. The cost cap valuation is dealt with from paragraph 30 onwards. It's completely different, and it is based on various complex complex paragraphs between 30 and 43, really at 42, direction 42, page 111, summarises it, and the cost cap cost of the scheme is A plus B minus C, so that's the future service costs plus the past service cost less the contribution yield. But the future service cost which is calculated by reference to direction 40, makes the same assumption at 40, subparagraph 5, so you assume there's no transitional protection. So again, it just focuses on what the costs are going to be under the new package of benefits. That, I say, is plainly consistent with section 12.1, but is the purpose of section 12.1. Bearing in mind the time I have, I think that's the best I can do with those directions. The directions were then amended on various occasions after 2014. I should say I've introduced the directions as introduced in 2014. They were amended on various occasions over the years. Nothing, I think, turns on them, but at page 134, we have the amendment directions 2021, which are the ones that are the reason for the application. And in essence, what they did was add in what's called the McCloud remedy cost to the cost cap calculation. So rather than valuing the things that had been identified in the previous set of regulations, it did all of those calculations and then added in the McCloud remedy cost. We see that.
Sorry, when you say the previous set of regulations,
I'm sorry.
The regulations or the directions?
I mean directions. I know the answer. Sorry. Yes, the directions. There's no change, no material change, no change at all to the regulations until 2% and 3%. But the business end of these amendment directions can be seen at page 139, where changes are made to the cost cap valuation report. I'm not going to endeavour to summarise in any real detail, but the essence is this. The amendment required the cost cap valuation to take into account the changes in liabilities in the remedy period expected as a result of the McCloud remedy. And if one goes to 57, which is at page 142, simplifying it, getting down to the bare bones, what one has is that the cost cap of the scheme is calculated as A plus B, where A is the employer contribution correction cost that was calculated in accordance with Direction 42 and stated in the first valuation report, and B is the transitional protection remedy cost calculated in accordance with Direction 56. So it just adds in the cost of providing transitional protection to the broader cohort of members in the light of the McCloud and Sargeant litigation. And it inevitably was much higher because all you're doing is valuing exactly the same costs, which were much lower than the employer cost cap figure, and adding in these new costs, which negated what would have been very substantial floor breaches, and that would have resulted either in increases to accrual rates or commensurate reductions in member contribution rates. But that liability that's added in was not a change in the cost of the new schemes. It was exclusively, in my submission, subject to one caveat possibly, exclusively costs in the legacy schemes. Now there seems to be a dispute with that, and I'll deal with it. The remedy offered was a deferred choice, so that members could choose when they retired, or indeed when they retire in the future, whether they will take the new package of benefits or their legacy scheme benefits. Now, in fact, for the 1992 firefighters scheme, very unlikely that anyone will choose the new benefits because the old benefits are so much better, save in one specific circumstance. Which involves the member being dead because it's about survivors' rights. The members of the 2006 scheme, however, which was an interim reform in relation to firefighters, will probably choose the new scheme benefits. And those matters are dealt with in the judgment of paragraph 93, which is at page 193 of the core bundle. So it's certainly true that the deferred choice allows some people to choose new scheme benefits. But if they do choose new scheme benefits, there are no additional costs above and beyond the original costs of the original 2016 valuation, because that valuation assumed everyone would take benefits in the new schemes, assumed no one had transitional protection. So there are no additional costs from people who may have had transitional protection choosing new scheme benefits. So these benefits are, in my submission, necessarily legacy scheme costs. One caveat is that it's possible that additional accrual in the legacy schemes could change behaviour. So that if, for example, someone didn't have 9 years accrual in the new scheme, they only had 2 years because they had an additional 5 years in their legacy scheme, it may be that they will retire earlier because they can put up with 2 years of actuarial reductions. Whereas if they'd had 9 years of new scheme benefits, they may have behaved differently. So there may be some impact, but that's not really where the huge figures that were imported into the cost control mechanism come from. They're not really about changes in behaviour. They're about additional benefit provision, which, as I've said, has to be a change in the legacy scheme and not a change in the new scheme costs that, in my submission, the cost control mechanism is designed to identify. And as a result, where the learned judge said that paragraph 110 of his judgment, this is at page 200, core bundle,
sorry, page?
Page 200.
Yeah.
Mr. Justice Choudhury accepted that the overall purpose of Section 12 is to measure changes of cost of the new scheme. He says it's difficult to see how that necessarily leads to the conclusion that costs in the nature of the MRC are to be excluded. The increase in costs resulting from having to meet the MRC means there is a change in cost since the previous valuation. Current estimates are that it involves an additional cost of £4 billion a year. That's an additional cost which on the face of it gives rise to a substantial change in the cost of the scheme. In my submission, if the scheme is taken to mean the new scheme, that's not right. They are additional costs in the old scheme. I should clarify one matter. Paragraph 108, the learned judge said, it's not, as I understand, disputed that in principle MRC do amount to costs of the scheme. If one looks at paragraph 115, starts at page 202, at the second part, at the end of that paragraph, the last sentence at the top of 203 says Parliament's chosen formula of measuring changes in the cost of the new scheme does not, this is the judge's finding, does not intrinsically exclude transitional protections costs, even if such costs could, as Mr. Short appears to contend, be described as being solely a cost in the legacy scheme and therefore not capable of giving rise to any change in the cost of the new scheme. So certainly it was the submission that was made was transitional protection costs and McCloud remedy costs exclusively costs in the legacy schemes. They are not costs to be taken into account under the cost control mechanism established by Section 12. And as a shorter point, in fact, two points. First, it's a cost resulting from remedying past discrimination. And that in itself is outside the purpose of the regime in Section 12 in particular. It's remedying a civil wrong done by the government. And secondly, it's not
isn't that the crux of your argument?
Yeah.
That actually the cost comes out in pension terms because we're talking about a pension scheme.
Yes.
But actually the cost is the result of a civil wrong.
Yes.
And therefore it's of a different nature. That is your case.
Well, I know certainly now, yes, it is. That it is a different element of it, but it's a civil wrong. It's quite different to what's envisaged. It's not even a change in cost. Certainly, the McCloud remedy didn't exist in 2015, but the right did exist in 2015. Now, the right wasn't acknowledged in the early evaluation, but people had a right to transitional protection, even if they were, on the face of the rules, being excluded from that right by unlawful provisions. Because the effect of the decision of the Court of Appeal wasn't to create new rights, but it was to reflect rights that had always existed because of the non-discrimination rule and the sex equality rule in relation to sex discrimination. And so,
Can I just be sure I understood this? Everybody who is entitled to a McCloud remedy was moved into the new scheme in a discriminatory fashion, is that right?
Yes, there was certainly, they purported to move them.
Purported to move into the new scheme.
The effect, in my submission of McCloud, was that the provision in the transitional provisions that said, and if you were born before X date, was unlawful, that was struck through, and that reflected everyone's actual rights, even though they weren't identified, weren't recognised by the government, weren't reflected in the valuation. So this wasn't a change in the substantive position, it was a change in what was acknowledged to be the position as a result of the decision of the Court of Appeal, which made it impossible to resist.
So if you assume that everybody opts back into the legacy scheme, and as you say, the people who don't opt back doesn't matter because it doesn't affect anything, and instead of the less benefit accrual in the new scheme, they get a more generous accrual in the old scheme. And is it the comparison between those two which is the remedy cost?
Yes, effectively. It's the remedy cost is the additional cost of allowing people to choose. That will be some people who were given transitional protection but didn't want it. They're the 2006 scheme members. but there's no additional cost for them. But mostly it's the cost of people who were aged firefighters who were under 45 on the March 2012, who suddenly were given the right to benefits in the old scheme, which were much more valuable, which have a higher cost. I think, in fact, all of the benefit, the way the Act, the Act remedying these things works is everyone's been put back into their legacy scheme for these purposes. They ultimately make a choice, but it will be of one set of benefits or the other. But the additional cost is the additional cost, the difference between new scheme benefits and old scheme benefits. That's the only cost, and that's necessarily paid out of the old schemes.
Don't worry which scheme it comes from. The bit you showed us in the 2014 directions of the preliminary valuation, although, as we discussed, was necessarily a valuation of the old scheme because it was as a 2012, when the new scheme didn't exist, was calculated by reference to the benefit structure in the new scheme in the implementation period from 2015 to 2019.
Yes.
Is your point this, that by putting the McCloud remedy costs in, what you're doing is you're changing the benefit structure which you're valuing from what it was in 2014, which is the new benefit structure, to what McCloud entitles the members to, which is the old benefit structure, which is more expensive. And so that doesn't change, doesn't measure a change in the costs of the new benefit structure,
Yes.
although it does measure a change in the costs of the overall pension arrangements.
It doesn't change the cost of the new structure at all. And I also say it doesn't reflect a change in the actual benefits, even in the old scheme, albeit that some of those benefits hadn't been recognised because transitional protection was provided on a discriminatory basis, but that was ineffective.
But under the 2014, you ignore the transitional protection. Now,
Yes.
Because you showed us that bit in Regulation Direction 53, which says
Yes.
you 53.6, you treat people as not entitled to transitional protection. So for the purposes of the valuation in the 2014 direction, everybody's assumed to be accruing benefits in the new scheme.
Yes.
But it doesn't matter, as far as I can see, whether people in fact had an unacknowledged right to the McCloud remedy or not, because in 2014 you treat everybody, transitional protection or not, as if they're accruing benefits on the new scheme basis.
Yes.
I thought your point was, by putting the McCloud costs in, you're not measuring a change in the cost of those benefits, you're changing the benefits which are measured.
Yes, there are three things. One, you are changing the benefits that are measured. Four things. One, changing the benefits that are measured. So it's not a change. For that reason, it's not a change in the cost of the new scheme. Secondly, the change is exclusively to benefits in the old scheme, so it's not a change in the benefits of the new scheme. Thirdly, it's not a change at all. You are changing what you're valuing, but the benefits themselves haven't substantively changed. And finally, perhaps most importantly, it's all designed to pass on the cost of a civil wrong to a group of people who are actually the ones who cannot benefit from the remedy.
Well, some of them can't.
No, my lord, none of them. Anyone who can benefit from the additional cost will be staying in the legacy scheme.
Yeah, but they're going to move into a new scheme eventually.
That's true. I'm sorry. So for that is quite right. But for 3 years, they will suffer. They won't pay any part of that cost. If they're still accruing benefits in April 22, they will pay for the last year. But for the first 3 years, the only people who will pay are people who do not benefit from the additional cost of the McCloud remedy. Even because, as I've said, even the ones who transfer to the new scheme as part of their deferred choice, or new scheme benefits rather, that's not an additional cost of the McCloud remedy.
Well, that wraps up two different points. One is what Mr. Giffen below described as a jury point, which is, this is outrageous. You're the one who've discriminated, and you're passing the costs on to the victims. And people who aren't even victims don't even get the benefit of the redress.
Yes.
That is a jury point.
Yes.
I haven't quite understood how it translates into a legal point. Because if they are costs within the statute, the fact that the government has used the statute to pass on costs which otherwise fall on the taxpayer may give you a sense of moral outrage, but it doesn't necessarily give you a legal argument.
No, although it is, I know the government uses government when it says we have the power to do this, and it uses taxpayer when it's being asked to pay for something. It's the same body, effectively, in these circumstances. But I hope it's more than a jury point, because one looks at what Section 12 was intended to do. It was intended to deal with things that changes in longevity that weren't captured by the link to state pension age. It was intended to deal with employment costs that weren't dealt with by making it a care average scheme. It was intended to deal with the costs of the new regime that was being introduced. It simply wasn't introduced in order to deal with costs of remedying wrongs, even if they happen to be in this field. And the government didn't pass the cost on to the victim. That would have been possible, theoretically, by increasing the accrual rates for the legacy schemes, because anyone choosing the remedy will have to pay legacy accrual rates. But one can see all sorts
contribution rates.
Contribution rates. But one can see all sorts of difficulties with requiring the victim to pay. So what they did instead was require the people standing next to the victim to pay. And that is not, in my submission, the purpose of Section 12. It's not to recover the costs of its own wrongs in those circumstances. It may be that's described as a jury point because it has an essential attractiveness, but that's why, in my submission, it is outside the purpose of the Act. And I only spend a moment, because in my submission, if that's correct, if that's outside the power of the Act, outside the purpose of the Act, then it's not permissible. I'll go to the ex parte Spath Holmes very briefly, because in my submission, it may be that the law itself isn't in dispute. It's much more a question of the purpose. But that's at tab 1 of the core authorities bundle. I'm going to deal with it relatively quickly, I hope. Lord Bingham at 381 between B and F, that's page 35 of the bundle, deals with this in the as the main issue. It's been sidelined, and unless it would be helpful for me to do something else, I'll simply identify the passages. That's been sidelined. It's between B and F, but it's essentially the Padfield point discretion so as to thwart or encounter to the policy and objects of the Act. Lord Nichols, at page 50 of the bundle, that's page 396 to 397. He agrees with Lord Bingham, although he disagrees in relation to something else on Hansard, which isn't material, but he gives his own statements, and it's in particular at 396 D to F, and then B to C, in particular on 397, although you see that parties are sidelined rather than more. Lord Cook says that he largely agrees with Lord Bingham, doesn't take it much further than that. Lord Hope also agrees with Lord Bingham, and that's at pages 58 to 61 of the bundle, and I think Lord Hutton quotes Padfield as well at 66 to 67. Those passages are marked. But those, in essence, are our submissions in relation to the first round of appeal, and I propose now, who thinks otherwise, to move on to the discrimination grounds. Three grounds of appeal that deal with discrimination. Ground 2 concerns the need for a causal link between the provision, criterion, practice, the PCP relied on, and the disadvantage relied on. It's a question of causation. Grounds 3 and 4 deal with objective justification. So I'll deal with ground 2 first. In outline, our submissions on ground 2 are as follows. Indirect discrimination requires, amongst some other things, a causal link between the PCP and the disadvantage relied on. It also requires that the disadvantage is a particular disadvantage to those sharing a particular protected characteristic, i.e. the disadvantage has to have a disproportionate or disparate impact in relation to one person with a particular protected, or a group with a particular protected characteristic and others. Contrary to what I submit were the judge's findings, there can be no doubt whatsoever that there was a causal link between the PCP relied on and the disadvantage complained of. The PCP relied on was the inclusion of the McCloud remedy cost in the cost control mechanism. That's the PCP. The disadvantage complained of is the negation of floor breach and the consequent loss of the increase in accrual. And there is no doubt that that PCP caused that disadvantage. And so the causal link is beyond doubt. Now, the reason this had a disproportionate impact upon the younger and more diverse cohort of members is that they would be affected by it, whereas the older and less diverse cohort, who were members of a legacy scheme in 2012, were less likely to be affected between 2019 and 2022 because it was more likely they would be able to stay in the legacy scheme, and so they could avoid any impact until April 2022, the 3 of the 4 years. Now, the reason for the disparity...
Can I just be sure I
Yes.
understood? The remedy period for McCloud runs up to the end of March 22. That's the period for which you can opt back.
Yes.
But the implementation, the period over which the McCloud remedy cost is spread, so where it affects your contribution and accrual rates, runs up to April 23.
Yes.
So you've got, if you've entitled to the McCloud remedy, you have 3 years in which you can opt for the legacy scheme and 1 year in which you can't.
Yes, although you can exercise that option at any time until you retire, which may be in the future. You don't have to exercise the option.
Yes, that's a different.
But the relevant period, or the implementation period affected by the PCP is 4 years.
So once we get to April 23, going forward from April 23 onwards, McCloud remedy cost drops out of the calculations.
Yes.
Presumably, there must be another valuation.
There's another valuation which isn't going to take those things into account. I will check over lunchtime, but it may be that the position has been clarified in other ways, but it's forward-looking. There will be a new employer cost cap figure identified, employer cost cap cost identified, and if that's above or below the corridor, then benefits will be adjusted again, but it will be new.
Above or below what figure?
16.8%.
You go back to 16.8%.
Always 16.8%. If you're within 3% of that, up or down, nothing happens. If it's outside 3% up or down, then steps have to be taken either to change the contribution rate or, in the absence of agreement, to change the accrual rate to return you to 16.8%, or whatever the other figure is for the other schemes.
And this valuation cycles every 4 years.
Every 4 years.
So the one which includes the McCloud cost cap is as at when? 2016.
As at 2016, but it affects benefits between 2019 and 2023.
And so the next one will be as at 2020.
2020.
And it affects benefits and contributions from 2023
to
2027.
Yes.
Do we have to, has that been done? We want to assume so.
Has it? I would have thought not, but I'm told it has. Yes, we think it. We'll check that over lunch. We think it may have been.
Well, I mean, people are accruing benefits, have been accruing benefits since April 2023. They must have been accruing something.
Yes. What happened with the 2016?
There was a pause.
Even ignoring the pause, draft valuations were produced, or preliminary. They were called preliminary valuations or provisional valuations, I think. But they were available, although they hadn't been signed, except I think in Northern Ireland, where someone accidentally signed one, and they had to have specific legislation to say that one doesn't count. But I don't know if final valuations from 2020 have been produced yet, but we will check over lunchtime. But that's why I say that the disadvantage that is caused by the PCP. That's why people didn't get an accrual increase. Reason for this, the disparity, quite accept, is that only those, or to be entitled to the McCloud remedy, you needed to have been in a legacy scheme in March 2012. But that doesn't mean that the test isn't satisfied, because the complaint isn't brought in relation to that requirement. All that the test requires is that, as a matter of fact, there is a disparity such that there is a particular disadvantage to the group in relation to each protected characteristic. And the learned judge erred in focusing on the reason for the disparity rather than on the cause of the disadvantage. And this is, in my submission, quite clear from paragraphs 180 to 183 of the judgment. These are at pages, this is at page 231 of the core bundle, and it's really encapsulated at paragraph 183, which is where Mr. Justice Choudhury says, in these circumstances, Mr. Giffin is correct to say that the differential impact complained of was caused by a measure that is unchallenged and unchallengeable because of the 2022 Act. But that, in my submission, was simply the wrong question, which is, two questions: is there a causative link between the PCP complained of and the disadvantage? And secondly, is there a differential impact? Is there a disproportionate impact on members of a particular group? And the reason for that differential impact isn't part of the cause of action. Now, I will tend to refer to the protected characteristic of age. There is also reliance on protected characteristics of race and sex, but I'll tend not to deal with them because they don't add much, save for quite a lot of complication, not least because, for historical reasons, the sex discrimination, or the protected characteristic of sex, would operate through the sex equality rule, whereas the age and race operates through the non-discrimination rule, which are different, have different complexities, but the sex equality rule would require the claimants to establish indirect discrimination. So there's nothing material to be gained by dealing in more detail with the other characteristics. The section 19 of the Equality Act is in tab 2, page 7 of the legislation bundle. And there's a person, A, discriminates against another, B, A applies to B a provision, criterion or practice discriminatory in relation to a relevant protected characteristic of B's, and then a PCP is discriminatory in relation to a protected characteristic of B's if the following is satisfied. A applies or would apply it to persons with whom B doesn't share the characteristic. That's not in doubt here, it was applied to everyone. That's not a defence, it's part of the cause of action. B, it puts or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons with whom B does not share it. C, it puts or would put B at that disadvantage. And D, it's not justified. D, of course, is the subject of the rounds 3 and 4. Causation is B and C. And it may help for me to make clear there are two elements to the phrase particular disadvantage. There must be a disadvantage in essence, there must be a detriment, something bad must happen. At that stage, it's not a comparison with people who have other protected characteristics, and one sees that from subsection 2C, because B, victim of the discrimination, doesn't need to show there's a particular disadvantage, they just need to show that they suffer the same disadvantage. So my submission, how this works, you need to show that the members of the group and the individual suffer from a particular disadvantage. Here I say that's the loss of the expected enhancement to the accrual rates. And also, it must be shown that the group who have this particular protected characteristic are at a particular disadvantage, i.e. it has a disproportionate impact on them, and there can be different ways in which that's shown. It may have a disproportionate impact on them because 9 out of 10 persons with a characteristic are affected, whereas 3 out of 10 people without that characteristic are affected. Or it may be because the effect in relation to people with a characteristic is more severe than others. But it's quite a broad test. There used to be the old law, which is mentioned in the Laing decision, the Aesop Laing decision I'll come to. It just dealt with proportions who could comply. But this is a much broader test. Now, on the facts, there can be no doubt that prior to the 2021 amendment directions, and in fact prior to the pause because nothing was happening, but in the absence of the amendment directions, the younger cohort were not going to be entitled to the McCloud remedy. Although the legislation hadn't been made, it had always been clear during the consultation process that the McCloud remedy would only be offered to those who were in the legacy scheme in 2012 when the changes were first announced. I think we need to go there, but in the supplementary bundle at page 249, there's a written statement from the Minister when the consultation on remedy was announced that makes that clear. And there was never any complaint about that exclusion. Certainly not in these proceedings, because very typical when a new regime is introduced, people who already have those terms and conditions sometimes keep them, and new people are given something else. And that's very often going to be justified, that kind of often that was called grandfathering, which is unfortunately a gender-specific term for something that has an impact in relation to discrimination. But it blue pencil, it was quite common. No complaint was made about that. But what the younger cohort would have been entitled to was an increase, or an expected increase, in accrual arising from the floor breach under the cost control mechanism. Now, in the case of firefighters, this increase, if applied across the board to accrual rates, would have changed the accrual rate from just under 1/60ths, it was 1 over 59.7, and it would have produced an accrual rate of closer to 50ths, i.e. 1 over 51.2. Those figures are in the judgment, paragraph 89, page 191. That would have been the default position. Alternatively, there could have been a reduction in contributions, and ignoring any of the complexities, simply on the maths, an equivalent contribution rate reduction to that increase in accrual doesn't take account of any of the variables, would have produced a reduction in contribution rates, under employee contribution rates in the new scheme of, I understand, 5.2%. So these were very substantial benefits that were expected. And the reason that those advantages, or a combination of them, wasn't enjoyed by members of the new scheme was the amendment directions, because they negated the floor breach and removed the prospect of those advantages. I'm just going to talk about accrual rates because it's easier, but it's one or the other or a combination. And that disadvantage occurred as a direct result of the 2021 amendment directions. And it occurred for members of the group, some members of the group, and some members, and all of the individual members for who weren't entitled to the remedy. And that is enough to satisfy the test of causation, because in the absence of 2021 regulation directions, they would have been in a better position. It's separate matter to show that the PCP relied on puts those who share a particular protected characteristic at a particular disadvantage. And one thing which can be difficult here is the number of times the word particular crops up, because it can mean, in the terms of the legislation, the particular disadvantage, i.e. a disproportionate disadvantage, and it can also be used in the more general sense of the one in question. But here, there was never any dispute that there was a disparate impact in relation to people with different protected characteristics. I won't spend too long on that, but the detailed grounds of resistance, which are in the core bundle, page 379, and this is paragraphs 25 and 26. And in fact, paragraph 26, says, it's said by the claimants that later members are on the average younger than the earlier members. Higher proportion of the later members than of the earlier members both belong to ethnic minorities and are female. This is not disputed, although both the earlier and the later members are predominantly white males. That's in relation to the firefighter scheme, not other schemes. The equalities impact assessment, which is in the supplementary bundle at page 466. Deals with this under the heading remedy status. This is a generic impact assessment, not specific to the firefighter scheme.
Sorry, which page?
466. And really the first bullet point summarises my case. I don't think this was ever contested, although its importance, of course, was contested. But members who are not eligible for remedy will have lower benefits by completing the 2016 cost control valuations, remedy included. This group is likely to include the youngest members. Group members are also more likely to be female and or to have other protected characteristics, including from other ethnic minority groups. Reference to disability, which I don't think is relevant to the firefighters, than the overall group of members affected by the 2016 valuation. So that is sufficient to establish disparity, particular disadvantage. Finally, on the supplementary bundle at page 237, this is a Treasury submission. It's dated the 27th of April 2020. That page doesn't.
No, the index says that. I think it is and must be the 27th of July 2020. I don't think it affects.
No, I'm very grateful.
It may matter for other arguments.
From 2020 is more important to me, though, because it's prior to the decision in relation to the 2021 amendment directions. But if one looks at page 241, equalities considerations, it says that paragraph 9, the assessment identifies that by nature and design of CCM, new members who are not in the remedy cohort will not benefit from the increased value of pensions resulting from remedy. These new members will nevertheless bear some of the associated costs. Newer members are likely to be generally younger, although not universally so, as people join public service schemes at all ages. Younger members tend to have other protected characteristics. So the transfer of costs could also have a disproportionate impact on them. No direct link between the proposed approach and the protected characteristic. But, in my submission, it's clear the government knew, when making its decision, that this would have disproportionate impact on younger and more diverse members, particularly because where it talks about associated costs, they were going to bear the brunt of the costs, certainly for the first 3 years. Now, I accept that the reason for the disparity is the need to have been a member of a legacy scheme in March 2012. I've called that the start date requirement, but that does not convert a complaint about the loss of an improved accrual rate into a complaint about exclusion from the McCloud remedy. So in other words, I'm conscious I may have said this in different ways at different times, but in other words, the start date requirement explains why the loss of the increased accrual rate had a disproportionate impact upon the younger and more diverse groups, but it doesn't explain why the increased accrual rate was lost, and the loss of the accrual rate was caused by the inclusion of the McCloud remedy costs in the cost control mechanism, and that is the basis of the complaint, that the increased accrual rate was lost. And I want to give one example, which I say is a comparable position, where the dates are going to coincide with the dates in Laing. But there may be a scheme may have been a pension scheme where everyone had a normal retirement date of 60. And that scheme may have been amended in 2002 so that any new members were given a normal retirement date of 65. But anyone who was already a member of the scheme kept their retirement date of 60 for all service, including new service. Now, later members, i.e. those joining after 2002, are likely to be younger. They won't all be, but as a general rule they will. But they may also be more diverse. But notwithstanding that, they would find it very difficult to challenge or to have challenged the 2002 rule for all sorts of reasons, including the fact that it's likely to have been justified. Protecting rights that people are already enjoying tends to be justified. And if a new rule was introduced today, whereby higher contributions were paid by everyone who had a normal retirement date of 65, it would only affect those who joined after 2002. Now, that would be a younger and more diverse group who, in my submission, would be able to bring a claim that the new rule introduced today, changing contribution rates today, put them at a disadvantage, and that there was a particular disadvantage to those who shared their protected characteristics. Now, it may or may not be objectively justifiable, but that's the next question. They would show disadvantage, they would show particular disadvantage. And that is the case, even though the reason for the disparity is the 2002 rules, rule change, that could not and wasn't, could not be challenged and was not challenged. And this is the position in my submission that's made absolutely clear by the decision of the Supreme Court in Aesop and Laing, which is in the core bundle, tab 5, page 149. The two joined appeals here, where the judgment is the judgment of Baroness Hale and the Deputy President of the Supreme Court, with the agreements of Lord Clark, Lord Wilson, Lord Carnwath and Lord Hodge. Aesop concerned the use of a core skills assessment test by the civil service as a requirement for promotion. And on the evidence, black and minority ethnic civil servants and older civil servants, which in this context meant over 35, were much less likely to pass than others, so they wouldn't get promoted. Or rather, those who failed the test wouldn't get promoted. Laing concerned pay scales for prison chaplains that were based on length of service. I should say, yes. All prison chaplains were paid by reference to a pay scale based on length of service, quite typically, but I think there were some financial matters which resulted in it being which meant that accrual did not happen as quickly. Claimant was a Muslim chaplain, that as the prison service hadn't employed Muslim chaplains before 2002, the length of service of Muslim chaplains and their pay tended to be lower than that of Christian chaplains. Now, both claims failed before they reached the Supreme Court, although Mr. Asplin had a temporary success in the EAT, and the Supreme Court considered the approach to indirect discrimination in some detail. Now, at paragraph 17 onwards, Baroness Hale deals with the development of legislation, domestic and European, in relation to indirect discrimination, up until paragraph 22. I do invite the court to read that, but I'm going to press on. Paragraph 23, the second sentence, Baroness Howe says, the whole trend of equality legislation since it began in the 1970s has been to reinforce protection given to the principle of equal treatment. All iterations share certain salient features relevant to the issues before us. 24, first salient features that in none of the various definitions of indirect discrimination is there any express requirement for an explanation of the reasons why a particular PCP puts one group at a disadvantage when compared with others. She refers to the 1975 Sex Discrimination Act, the Equality Act 2010. And then, right by the letter E, says it is enough that it does. So if there is a particular disadvantage, that's enough. One doesn't need to prove why. It's not part of the cause of action, although it will often be helpful to know why it does. At 25, Baroness Howell goes on to say a second salient feature is the contrast between the definitions of direct and indirect discrimination. Direct discrimination expressly requires a causal link between the less favourable treatment and the protected characteristic. Indirect discrimination does not. It requires a causal link between the PCP and the particular disadvantage suffered by the group and the individual. And pausing there, in my submission there, Baroness Hale is using the word particular in the sense of the disadvantage in question, because the individual does not need to show a particular disadvantage. She or he just needs to show that they are at a disadvantage, and it's the same one as experienced by the group. And going on, there's a description of what indirect discrimination is intended to do. It says the PCP is applied indiscriminately to all that aims to achieve a level playing field where people sharing a particular protected characteristic are not subjected to requirements which many of them cannot meet, but which cannot be shown to be justified. But that simply is an example of the word particular being used in a non-legislative sense in this paragraph. But what is important, I say, is all you need to do is to establish a link between the PCP and the disadvantage in question suffered by the group and the individual. Baroness Hale isn't talking about the disparity there, because she has already, in the first salient feature, said you don't need to explain why there is such a disparity. 26, the third salient feature, is that the reasons why one group may find it harder to comply with the PCP than others are many and various. Mr. Jones called them context factors. They could be genetic, social, traditional employment practices, but then what I rely on in particular, it says they could be another PCP working in combination with the one at issue, as in the Chief Constable of West Yorkshire against Homer, where the requirement of a law degree operated in combination with a normal retirement age to produce the disadvantage suffered by Mr. Homer and others in his age group. Pausing there, Homer's in the main bundle, but in essence, I think he was 60. To get promotion, he needed a degree. They had a retirement age of 65, and so he didn't have very long to get it, and that was held, subject to objective justification, to be indirect discrimination. Sometimes the phrase prima facie discrimination is used. It's not quite accurate, because discrimination only occurs when something isn't justified, but it's a helpful expression to identify the earlier requirements. But there, Mr. Homer could not have challenged a default retirement age of 65, quite apart from anything else. At the time, the age discrimination legislation had an exception for compulsory retirement at 65 and over. But he couldn't have challenged it, didn't challenge it. It wasn't said to be unlawful. But the combination of that other PCP and the PCP relied on in the litigation is what produced the disadvantage suffered by him and others in his age group. And that, I say, is exactly the position here. Even if the start date requirement is seen as a PCP, it's not the one relied on for this challenge. It is, though, one that works in combination, and they are both causes of the disadvantage. Removing one or the other would solve the problem, and that is made clear at the final sentence of paragraph 26. So here, the removal of either PCP would solve the problem, although removing the start date requirement PCP would solve a much bigger problem that is suggested by this litigation, would have much more far-reaching effect. The fourth salient feature, paragraph 27, says it's commonplace. For salient features, there's no requirement that the PCP in question puts every member of the group sharing the particular protected characteristic of disadvantage. That's a common feature of all indirect discrimination claims. Some tall women, even if overall a height requirement would tend to have an adverse disparate impact against women. 28, fifth salient feature, is that it is commonplace for the disparate impact or particular disadvantage to be established on the basis of statistical evidence. Well, pausing there, I say that is an indication that particular disadvantage, when used in the technical sense, is a reference to disparate impact, disproportionate effect. That's an examination of the group position. And the final point, 29, final salient feature, is it's always open to the respondent to show his PCP is justified. In other words, there's a good reason for the particular height requirement or particular chest grade. Some reluctance to reach this point can be detected in the cases, yet there should not be. And in essence, the court, in my submission, the Supreme Court was making clear that one shouldn't be reluctant to find the earlier requirements met on the basis that there is a moral stigma for the first three elements being satisfied, because of course there isn't, and it's only when justification has been taken into account that discrimination either has or hasn't taken place. Against that background, the court dealt with ESOP, and the conclusion really is set out at paragraph 33, so it encapsulates my case, where second paragraph, halfway down the paragraph, it's the third sentence. In order to succeed in indirect discrimination claim, it's not necessary to establish the reason for the particular disadvantage to which the group is put. The essential element is a causal connection between the PCP and the disadvantage suffered, not only by the group but also by the individual. May be easier to prove if the reason for the group disadvantage is known. That's a matter of fact, not law. And then at paragraph 37 onwards, the Supreme Court deals with Mr. Naeem's case, and in essence, I'm going to summarise, the reason Muslim chaplains had shorter service and tended to be paid less than Christian chaplains was a PCP, a practice of not employing Muslim chaplains before 2002. That's the reason for the disparity. But that wasn't challenged. May well not have been challengeable because no time had passed, but it may have been justified at the time. But that wasn't the basis of the claim. The basis of the claim was the PCP of the pay scales being operated now, and they, in conjunction with the failure to employ Muslim chaplains before 2002, is what caused the particular disadvantage, the disproportionate impact upon Muslims, even though the disadvantage itself was caused by the pay scale, and that's the matter that was subject to the complaint. He failed in the Court of Appeal, where Lord Justice Underhill said, and his judgment is set out in full at the top of, the passage is set out at the top of 163. The judgment as a whole, in fact, is in the main bundle. But at B, you see, he says, in my view, the only material cause of the disparity in remuneration is the on average more recent start dates of the Muslim chaplains. It doesn't reflect any characteristic peculiar to them, rather it reflects the fact that there was no need for their services as employees of any earlier date. And that was rejected as being the incorrect approach, and he was found to have satisfied the requirement for disadvantage and particular disadvantage. His case failed on justification in the end, but paragraph 42 says, in this case, PCP identified was the incremental pay structure which affected all chaplains. This did put the Muslim chaplains at a particular disadvantage compared with Christians. He suffered that disadvantage, and so section 19B and C were satisfied. The court then went on to look at objective justification. So, in my submission, in that case, absolutely four square. With this, the facts are materially indistinguishable. The disadvantages caused by the pay structure in IE, by the inclusion of the remedy costs in this case, the reason for the disparities, another PCP which isn't challenged, couldn't have been challenged, but that wasn't material. And finally, on this, my last submission on this point, the distinction between disadvantage and particular disadvantage is made clear in the judgment of Her Honour Judge Edie QC, as she was at the time. I think she was a permanent judge of the Employment Appeal Tribunal. This is in the new bundle. The facts are somewhat unusual. As someone who was a teacher, her husband, this is tab 6, I should say, of the new bundle. And my lady, I will finish in 2 minutes, and I will finish this point. The claimant was a teacher. Her husband was convicted of downloading indecent images of children and imprisoned. She determined that, consistent with her marriage vows, she would remain with him provided he demonstrated unequivocal repentance. She was dismissed, and one of the issues was whether Christians with the beliefs that she held were at a particular disadvantage by a PCP of dismissing people who stayed with their partners who'd been convicted of voyeurism and downloading child pornography. But the material passages are at 38. And also 42. 42 perhaps is the more straightforward. There's the focus on the general disadvantage suffered by those falling within each of the comparative groups, fail to have proper regard to the statutory requirement, which is to ask whether those falling within the same group as the claimant, sharing the relevant characteristic, faced a particular disadvantage. PCP of neutral application may seem to give rise to a general disadvantage for all concerned. That does not mean it does not give rise to a particular disadvantage to those sharing certain characteristics. And that difference between particular disadvantage, which is suffered here for the factual reasons, and the general disadvantage, in my submission, is helpful in identifying that here the disadvantage was caused by the PCP. My lady, I am sorry.
Thank you very much indeed. To the floor.